Good morning, everyone. This is our fourth presentation. This one will be on the contractor qualifications under COVID-19. When you're making purchases now in the current situation that we're all facing, where the possibility is that you're having to do sole source purchases in addition to competitive purchases, one of the responsibilities that you have in doing that purchase is that you need to make sure that the contractor meets the qualification criteria established by both FEMA and the Office of Management and Budget. Federal Emergency Management Agency has required that you comply with certain directives, and the Office of Management and Budget, OMB, has also required that compliance. One of the issues that you're facing in all of your purchases, regardless of whether it's under COVID-19 or not, is that you must determine whether the contractor is responsible. Responsibility means that the contractor has to meet certain criteria. Contractor responsibility is required by the Super Circular 2 CFR 200 and also FEMA directive. Contractor responsibility is something you have to make a determination of even if you're doing a sole source purchase. When you signed up and you hit the subscribe button, there's an opportunity for you to ask questions in the chat box on the right-hand side. You'll also notice when you signed up that there were some links at the bottom of the description. The links will have a copy of the FEMA fact sheet, also the OMB 2 CFR 200 and the OMB memo of March 9, 2020. If you're interested in anything after this session's over with, please shoot us an email in the address below. Okay, now, as I indicated here, these are the two items that you are required to comply with. FEMA directive requires that before you make an award, you have to analyze the contractor's responsibility. It also requires that you incorporate certain clauses in your award. Both of these documents require compliance with responsibility determination and making sure that the contract contains certain clauses. The term responsibility means that the contractor has to have the capability to perform in accordance with the contract that they're going to be awarded. And that means both the scope of work, the budget, and the terms and conditions of that contract. The terms and conditions are going to be required clauses that are established by the OMB Super Circular. In order to ensure that the contractor is capable of performing successfully, the tribe has to make an analysis of that contractor prior to the award. And you have to look at 5 different factors: contractor integrity, compliance with public policy, where public policy means tribal law, state law, and federal law. And you also look at the history and the record of that contractor's past performance. And finally, the last two items, you look at whether or not the contractor has the financial resources and the technical resources, or has the ability to obtain them. One of the things that is in the link that I attached at the bottom of your sign-in is a certification requiring that the contractors certify as to whether they are debarred, suspended, or proposed for debarment, and any other matters that apply to responsibility. Prior to making this award, you need to ask certain questions of the contractor. You can either ask that contractor to certify as to whether or not they're debarred, but you also have to do a debarment investigation yourself, over and above the form that the contractor is going to submit. Now, the form that the contractor submits, the one that I gave you on the link that you have at the bottom of your subscription page, requires the contractor provide you data. But you yourself also have to investigate that contractor's background. One of the things that you have to do is to do a what's called sam.gov investigation. What this entails is that the tribe, before you make the award, will go on to sam.gov on the internet, and you will look up whether or not the contractor is or has been debarred or is being proposed for debarment. Now, what I'm going to do here is I'm going to click on that link and take you to, now you notice in the link on your PowerPoint slide, it says sam.gov/SAM. SAM stands for System for Award Management, and all of the tribes, before you can receive a grant, are required to register. Now, one of the questions that I've been asked in the past is a contractor required to be registered on SAM? No, they are not. And so, oftentimes when you go to SAM, you may or may not find the contractor information. Now, that does not mean they are bad or good. It just means that they have never contracted with the federal government directly. Now, you notice in the link that it says search records. So let me click on this link, which when you download this from your,
Control click will.
pardon me?
Hit control and click.
Okay, hold on a second here. All right. Now, when the link pops up, you'll notice there's a menu bar right under SAM. Click the menu that says Search Records. And then scroll down, and you'll have a place where you can put
Full screen it.
to the name of the individual or the name of the company that you wish to search for. Now, one of the things that you should be thinking about here, when you do this search, one of the things that contractors might have done in the past is they changed the name of the company to protect the guilty, so to speak. And so when you do your search, you need to insert where it says quick search there, both the name of the company and then do a second search where you're going to link and look for the name of the principal of that company. So, search the company, name, and the principal of that company. In other words, you're actually looking for who is the owner or chief executive officer of that company, and you're trying to determine whether or not that individual has been debarred. Now, let me enter a name here for you here to illustrate what you're going to find. By the way, as a comment for you here, it doesn't matter the size of the contract that you are entering into. You're supposed to search for the contractor on the debarment site, even though the contract may be only several hundred or several 100,000. So I entered the name of an individual, and now I'll click on the search link. Now, you notice where it says record status, and beside the individual's name, it says exclusion. Now, what this means for you is that the individual that I searched for, who is the owner of a company by the name of, it used to be Blaze Construction, now it's changed that name, but he has been debarred, and what you need to do is to screenshot and print this page. Your audit requires that this page be kept in the files. Now, if you wanted to, what you could do here is to go over on the right-hand side of that screen where it says View Details, and we could look at the information, the detail as to how Mr. Aubrey and his company were debarred by the funding agency, which I'll show you here just as an indication. And you'll notice that he was debarred by, and it is an indefinite debarment, and it was by Housing and Urban Development. HUD debarred Mr. Aubrey. Now, you're not allowed to contract with Mr. Aubrey or his company. Okay. All right, let me get rid of this little. Did they have that, Mike?
Yes, they did.
Okay.
Whatever's on your screen they have.
Okay. Are we all right?
Yeah.
Okay. Now, the individual and or that individual's company has been debarred by the federal government from all contracts present and future indefinitely. However, SAM.gov is only a federal debarment. And unfortunately, when you do an investigation of the contractor on SAM, you're not finding out whether that contractor has been debarred by state or tribal entities as well. And one of the things that you need to investigate is whether or not the contractor has been debarred. If they're not debarred by the federal government, whether they may have been debarred by the state or by a tribe. The easiest way for you to do that is for you to ask the contractor to submit the certification that is on the bottom of your subscription page, where the contractor certifies that they have or have not been debarred by a federal, state, or tribal entity. Now, this is a form that I developed in the past for other tribes, which you can download if you wish, and then prior to making the award to the contractor, ask them to fill out this form. It's released, you can use it, you won't be considered to be plagiarizing. Now, the very first question on this form asks, has the contractor and any of its principals. Now, if you'll notice, I put up the word here, principals, which means the owner, the chief executive officer of this company, and senior managers of this company. Have any of them been debarred? Now, the question asked here on the form, it says, has the contractor been debarred, suspended, or proposed by debarment by federal, state, or tribal? We have a question that's been asked by one of the viewers.
Where do we find this form?
When you subscribe to the link on the bottom of the subscription page, and let me click back on a couple of, let me get out of this. If you go back to, hold on a second. Okay. Okay, when you hit the subscribe button, on the bottom of the subscribe button, there are links which includes the Office of Management and Budget Circular, 2 CFR 200, a FEMA memo, a FEMA fact sheet, and a contractor debarment certification form. If you click on that link for the certification form, and then you can print that form, and any contract that you award, you can send that form to the contractor. And then the contractor will be required to fill it out. And when the contractor fills it out, they are asked several questions. On that link for the certification form, and then you can print that form, and any contract that you award. We've got a little bit of a feedback here. All right. Now, as I said, the very first question asks the contractor, are you or are you not debarred by federal, state, and tribal? Now, one of the problems that we face here on this debarment issue is Sam doesn't have state data. Now, you can look up in your state the debarred contractors from your state. So if you just do a Google or a browser search in your state for state debarred contractors, you can find out what contractors have been debarred by your state. And you're going to find out that there are actually a fairly substantial number. One of the tribes in Washington contacted me and asked me a question. They said, we searched on SAM and we didn't find the contractor, and then for whatever reason they decided to search on the state, and this was a tribe in Washington state. And so they went on to the state of Washington debarment page, and they found the contractor had been debarred by the state of Washington. And then they contacted me and they asked me the question, said, if they weren't debarred by the feds, but they were debarred by the state, can they award the contract to the contractor? And I said, no, you cannot, because a sovereign government, federal, state, or tribe, has found that contractor to not be responsible. Okay, now to continue on that illustration, for tribal debarments, there is no national database, and we cannot go on a Google search or a browser search and find a debarred contractor who has been debarred by a tribal entity. Just to give you a little example, Blaze Construction had a contract, 10, 12 years ago with the Hopi tribe in Arizona. Because of a breach of contract, they were terminated for default and they were debarred by the tribe. They then went to Navajo and submitted a bid on a $16 million contract with Navajo. And this was actually with the Navajo Bureau of Indian Affairs, and the Bureau of Indian Affairs did a search on SAM.gov. And it turned out that Blaze Construction had not, at that time, been debarred by the federal government. But the Bureau of Indian Affairs did not ask Blaze had they been debarred by a tribal entity. And because they didn't ask that question, they didn't find out that Blaze had been debarred just prior to the contract with Navajo by Hopi. And they went ahead and they awarded the contract. And it turned out they actually had the same problem with Navajo that Hopi had had with Blaze as well. So it behooves you as a tribe to ask the contractor to certify, and when they fill out this form, they indicate whether or not they have been debarred by all three or not, federal, state, or tribal. Tribes, because you are a sovereign government, have the ability to debar a contractor. And you don't want to award a contract to a contractor who has been debarred by any of these three entities. Okay, let's go through a couple of others here. All right, now you'll notice in the links that I had here, the form allows us to determine whether or not the contractor has a debarment history, federal, state, or tribal. The form also, which if you download it and you send it to the contractor, it also asks the contractor, have they been convicted or indicted or have a civil or criminal judgment against them for several of what are called white-collar crimes. The white-collar crimes are embezzlement, theft, forgery, bribery, falsification, or destruction of records, or making false statements, tax evasion, or receiving stolen property. The only way you're going to find this out is if you ask the contractor to fill out this form. They would then acknowledge whether they have or have not had a criminal conviction. Now, again, the interesting part of this is that, and in the kind of situation that we're facing now, where we're having to do sole source purchases in an expedited manner, we don't have the time to do a criminal search of a contractor. But by asking the contractor to fill this form out, the contractor then professes whether or not they have or have not had that conviction. So, as part of contractor responsibility, you want to find out whether the contractor has a criminal history. Yes or no? Now, the criminal history that we're looking in here, as I indicated, is what's called white-collar crime. You're also required to do a criminal history background for child crimes as well. We have a question from the audience.
This is a question from Julia Jeffroy. For a tribe to debar a contractor, would they have to have used tribal funds only? Or if it was federal funds, would the tribe be able to input information into SAM?
Thank you for the question. Because tribes are sovereign governments, tribes have the power, the authority, just as the state does, just as the federal government does, for the tribe to debar a contractor. Now, the process by which you would do that debarment, and let me make some notes up here on the board. For a tribal debarment to happen, you must give the contractor what's termed due process, which means then that you would inform the contractor that you have a finding against them. You would then call for a hearing, and at the hearing, the contractor would be entitled to representation, and they would be, you would submit evidence against them, and they would allow you would allow them the opportunity to cross-examine and to submit rebuttal. Once the hearing has been done, and let's say you have a finding of guilt. Once that finding has been done, then you must have a council resolution which would document it in the context of tribal authority. So the hearing would be conducted in all likelihood by the procurement office with program staff and those individuals who have information about the contractor. And let's say the contractor, as an example of what they may have done, they've falsified their invoice for payment, and they've submitted false information, or what's termed in contract law a false claim. You have data supporting your position, they have a claim, you conduct the hearing, you allow cross-examination, you allow them to submit evidence, and cross-examine, etc. And then once you do the resolution, back to the question which was asked, the tribe now has issued a termination for the contractor for default and a debarment. That's a tribal decision and only has impact on the tribe. Because if you have that contract funded with federal money, and let me make a note here, if federal dollars, you can submit to the funding agency. And they will also do the same process. And if the contractor has submitted, or has, committed an offense which the funding agency considered egregious enough, such as embezzlement, false claims, or violation of federal law, not only will you debar them, which prohibits them from contracting with you in the future, but the funding agency would also go ahead and debar them, which would prohibit them from contracting with any tribe funded with federal money. You also have the ability to submit it to your state agency, which would then prohibit that contractor from receiving state contracts in the state which they would be then debarred by. So, it's to your advantage, going back to your question, to not only you debar them, but also submit them for federal debarment, and that way other tribes would not have or could not contract with that same entity either. So, tribal debarment only prohibits the contractor from contracting with you. Federal debarment prohibits the contractor from contracting with anybody if they are funded by federal dollars. Okay? All right. Now, let me go back just here. Now, one of the things I mentioned earlier under responsibility is that the tribe needs to look at 5 different factors. The first factor was integrity. Under the issue of integrity, and let me click forward here, there's 2 factors or 2 sub-factors that I think are important. First one is debarment status, and the second one is the issue of Indian preference. And one of the things that the contractor can do under both competitive and sole source procurement is that the contractor can claim Indian preference. And they would say, we are an Indian-owned economic enterprise. Well, this in turn requires that you conduct an investigation of that contractor to determine whether or not they are truly an Indian-owned economic enterprise. And in order for that to happen, they must meet the criteria in 48 CFR, as you can see on the PowerPoint slide, 1480.201. Now, what's happened in the past is that contractors will claim to be Indian owned, but that's not the only factor that the contractor has to demonstrate. There was a contractor, I'll give you an example, in Montana that claimed to be Indian owned, and the owner of the company was a member of a federally recognized tribe. They had more than 51% ownership. However, when you looked into the background of that company, it turned out that the manager of the company was non-Indian, and the person who was the manager was also the individual who held the construction contractor license. They were also the individual who had the experience and expertise, and they ran the jobs. Now, that individual exercised management control, and they had the qualifications and experience. Ownership is not the only issue. You must demonstrate all of the factors there that are identified. Ownership as well as management, control, and under the issue of control would, for example, be licensure, such as construction contractor license, and then experience, qualifications, and obtaining the resources necessary to do the job. Ownership is not the only thing. A lot of companies will have ownership, but in reality, they are what would be termed a front. So, Native American status is the second factor that you would look at under integrity. Obviously, if a contractor is debarred, then they are lacking in integrity. A contractor that claims to be Native American but doesn't have management control, experience, qualifications, or providing the resources, they are falsely claiming to be Native American, Indian-owned economic enterprise, and in reality, the ownership is merely a front. That would indicate that they are lacking in integrity as well. Okay, let's go to the next issue. There are, as I indicated earlier, 5 factors that the tribe must investigate to determine responsibility. The next factor is what that contractor's past history of compliance was. Now, one of the key issues here, and this is kind of goes along with the integrity one that I mentioned just a minute ago, compliance with tribal law, TARO, Tribal Employment Rights Ordinance. Has the contractor in the past history shown a history of non-compliance with Tribal Employment Rights Ordinance? Now, the Tribal Employment Rights Ordinance, the purpose of it is to make the contractors employ tribal members in doing the work on the reservation. And the contractor, you have a clause that says they must comply. And oftentimes what will happen is the contractor will initially hire tribal members, and then shortly after the contract has been awarded, those tribal members are no longer employed. Nor does the contractor put tribal members into management positions within the contract as well. So a history of non-compliance with TARO would be grounds for saying this is a contractor, that's not responsible. The other thing you would look at would be state and federal non-compliance. In the case of state, look up the contractor's history under your state office of consumer protection. And you'll find perhaps that the contractor might have had a history of non-compliance. The other thing you might consider doing is going on to the federal government's Department of Labor Wage and Hour Division and look to see whether the contractor has complied with OSHA and Davis-Bacon. Those are two typical areas where contractors might have had a history of non-compliance. Now, one thing I should have noted earlier, if you find non-compliance with any of these issues here, we're going to reject if non-responsible. Okay. The next issue, and let me click forward on the PowerPoint. Past performance. Now there's an interesting element in this regard here. When you look at the law under the Office of Management and Budget Super Circular, it says history of past performance. Now, in that context, what this means is that you must have a record. Suppose the program, the procurement office, asks the program, what do you think of XYZ contractor? And they say, we don't like them. We've had problems with them. That's without any substantiating documentation. That's considered hearsay and will not be valid grounds for rejecting the contractor. So you must maintain a diary. And the detail within that diary is going to show you whether or not you're going to be able to declare that contractor either responsible or non-responsible. Now, the next thing about that history, it doesn't have to be your own tribe's history with that contractor. It could be any other tribe, their background with that contractor. And one of the things that you should do is you should ask, when you ask the contractor for some of their, let's call it resume, and they're going to give you references as to who they've done business with. Now, just like any other individual, they're only going to give you their good references. Look for gaps in that history. So the contractor will say from 2008 to 2009, we worked with tribe XYZ. And then the next tribal contract they had started in 2011. Well, what happened in 2010? That's the one you should check on and find out who did they work for in 2010. Look for the gaps in the history. So, history with tribes, history with the state, history with the federal government. Record of past performance. The next element that you look at is the contractor's financial resources. And there's a kind of an interesting little side note in reference to this one. They either have it, question mark, or can they obtain, question mark. Now, if they have it, then you're going to look at things like their bank records, their bank letter of credit, their bonding capability. But let's suppose this is a brand new company and they just started up and they have the qualifications, personnel, but they don't have a financial track record. Well, if they can obtain a line of credit that would allow them to perform your job, then they are considered financially responsible. So a new company that can obtain that line of credit is just as responsible as a company that's been in business for 20 years and has a good financial tax records and financial statements. So, financial responsibility, one of the things you're going to look at is, do they have it or can they obtain? Now, you notice on the PowerPoint slide there, I mentioned their DUNS rating. DUNS rating, or Dun & Bradstreet, if a contractor is registered with SAM, you'll be able to pull up their DUNS rating from that contractor. If not, you can contact Dun & Bradstreet directly and ask for the Dun & Bradstreet rating on that company. The Dun & Bradstreet rating indicates how they paid their bills. Do they have a good history of paying their creditors, their suppliers, for their bills that they incur in the work that they've done for past contracts? Let's say, for example, the organization hired a supplier or a subcontractor and they did not pay that subcontractor and there was no payment bond required, well, then they don't have a good Dun & Bradstreet rating and you would face the same risk with that contractor as well. Now you notice also that bonding capability bonding is required if the contractor are going to be doing a construction contract. And there are 3 bonds that the contractor has to obtain. A bid bond in order to bid on your job, a performance bond if you decide to make the award, and a payment bond if you make the award to the contractor. Is the contractor able to be obtained that bond? If they can obtain the bond, they normally will be viewed as having the financial wherewithal to be considered responsible. Okay, the last element of responsibility investigation is what's called technical resources. And underneath this, you have two subsets. Does the contractor own or possess, or can they obtain either the staffing or the equipment? A few years back, we had a very, very large construction contract in Albuquerque at what's called the Big I, where I-25 and I-40 intersect. And it was a multi-year contract, excuse me, and the contractor that was awarded that contract was required to have equipment in order to do the job. And the equipment that they owned and the equipment that they had to rent used up almost all of the equipment that was available in the Albuquerque area. Other contractors were unable to obtain heavy equipment because this one contractor had used it all up. So other than that one contractor, if you were trying to contract with somebody and they could not obtain, then they would be considered non-responsible. Now, you notice it says staff with qualifications. Suppose you wanted to contract with Bill Helmich Associates and you wanted us to do a forensic audit. We do not have staff who have those qualifications. But could I subcontract with an individual who does have that qualification and provide that individual for your job? I know of a lady in Oklahoma who is a forensic auditor and has that capability. If she's available, then we become responsible. So either you have them or can obtain them. Now you notice under the equipment, it has to be the equipment needed by the job that you're trying to perform. Okay, these are the 5 major factors of responsibility. I'll scroll back here. Hold on a second. There. Contractor integrity. And let me enlarge that for you. There. Compliance with public policy, record of past performance, financial resources, and technical resources. One key element in all of those, you must document that you have identified that the contractor does or does not possess those criteria. If they do not, and you determine them non-responsible, without the documentation, you're not going to be able to declare them non-responsible if the contractor files a protest. So these elements are crucial. Document. Okay, if you wish to keep in touch with us, please send us an email and we'll put you on our mailing list for any future video presentations. The video will be put up on the web page for future availability. The PowerPoint slides will be linked and you'll be able to download the PowerPoint slides as well as the other links that you found on the subscription page. Thank you for watching with us. Stay safe, good luck, and we look forward to seeing you in the future.
Right on time. Actually, as soon as I said that, it went.
Really?
But it was starting to trend.
Yeah. Well, I knew I was getting a little long, but I knew I had a couple feet left, too.
Yeah, I mean, should end this with, like, if you have any questions, please submit them now. I'll hang out.
Shit.
You're still watching.
Right now?
They can't hear you, but he's got slides up.
Oh.
You want to say that?
Yeah. By the way, I forgot to add one additional comment here. If you have any questions that you would like to submit, even though the presentation is completed, go ahead and submit it on the chat and I'll hang around and will respond both online and in writing if you so desire, whichever way you would like it. So, any questions, we're still available here for you.
Terry Jackson says, thank you, Bill.
Thank you, Terry.
You're muted now. I'll ask you. There's nothing coming in.
We'll take a couple minutes. That's a good point, Mike. Thanks. Sure.
Take a 2-minute delay.
Yeah. But we never, I didn't do that on any of the other ones, and that's something I should have done.
That's what I would start. Don't go right into it. Like, hey, how's your day?
Yeah, I did again, didn't I?
It's called a learning experience.
I know, but Mike mentioned that last time.
Well, you're a slow learner. So we're approaching 60 minutes and there's no more questions or no more anythings. So maximum topped out at about 20. And it was I was telling Mike, what you were talking about is exactly why they started asking, when we made on-site bids, contracts, they started asking for all the crap that you just asked us, that told them about. The Duns and us, Bill Helmich Associates. Don't you remember I told you that?
Yeah. Well, that's because I tell them.
Yeah, and then I said, yeah, thanks a lot. I told Mike.